so that they earn. That is the state how it earns. Otherwise, you are yourself doing it by selling it off to someone else, which we will not allow.
We did not sell it off to
We
someone.
are doing it. We can see it very clearly.
5 years.
When did you give the notice?
Several notices are there, Your Lordship, and in para 11 they have accepted that they have admitted that the unit was closed. Your
When
Lordship.
did you give a notice?
Yes, Your Lordship.
How could you give a notice within up to 2014 it was functioning?
It was not functioning, Your Lordship.
You
It is
just
there.
now said.
It,
You just now said that it was functional till 2014.
Till 2014.
And 6 years means 2020.
And
So if from 14, how could you give a notice in 18?
Your Lordship, this writ has been filed against the impugned order by which the allotment of land to the petitioner firm has been cancelled by the BIADA, Your Lordship. Initially, when the case was heard, Your Lordship, at length,
What was, why it has been cancelled?
it has been cancelled on two grounds, on several grounds, of them being initially that the unit is closed, it is not operational, and secondly that there were some dues which were to be cleared by the petitioner firm, and for that reasons it was cancelled, Your Lordship.
So, what is your ground of challenge?
Before the cancellation, the dues were already paid. That is acknowledged by the authority also. It is present in one of the letters they are addressing into between.
So, you deny this, that there is any claim left?
Absolutely, Your Lordship.
And what about the other aspect?
Other aspect regarding the operational, Your Lordship, my unit started in the year 2011. It remained operational. Recently, Your Lordship, because I have a unit of rice milling, it is a seasonal, Your Lordship, unit. And therefore, and some repair and maintenance work was also going on, for which I had sought time from the authority.
Where is
Yes,
that?
Your Lordship. Those representations are covered by Annexure 13, Your Lordship.
Where do you say in that Annexure 13? Show,
Your Lordship.
show that line. Yes, on the basis of merely because of is not operational, you can't be closing.
Your Lordship,
You can't be cancelling the allotment.
Your Lordship, the allotment was made on 2009. It is their own averment that the unit was functional till 2014. In the allotment letter itself, the clause 23, subclause B says, if it remains closed for more than 6 years and if it does not restart after giving opportunity, then the allotment will be cancelled. So it is their own acceptance that for 5 years.
When did you give the notice?
Several notices are there, Your Lordship, and in para 11 they have accepted that they have admitted that the unit was closed.
When did you give a notice?
Yes, Your Lordship. Annexure B series of my counter affidavit. In fact, in their writ also they have annexed the notices. That is on page 65, one of the notice. Your Lordship, thereafter.
Page
65. Thereafter, Your Lordship, another notice is on page 66.
So how could you give a notice within up to 2014 it was functioning?
It was not functioning, Your Lordship.
You just now said that it was functional till 2014.
Till 2014.
And 6 years means 2020.
And
so if from 14, how could you give a notice in 18?
No, but previous to that also we have given the notice. That is Annexure B
That's why,
series.
we are asking you something else. You may have given previous notices.
Yes.
But when the firm was functional up to 2014, where was the occasion of giving a notice before 6 years?
No, not before 6
You
years.
said that just now.
6 months, Your Lordship. That is, if it continues.
You said 6 months. 6 months.
If
your argument was that if 6 years.
Sorry, Lordship, I made a mistake. If it.
Whatever you say, it's a court of record.
Sorry. If it remains closed for more than 6 months, Your Lordship, then they are liable for cancellation. Right. That is clause 23 of the allotment letter itself says, Your Lordship. So it is their own case, that is, it remained closed from 2014 onwards, and we have cancelled in 2019 after 5 years of that, Your Lordship.
In the meanwhile, Your Lordship, we have prayed for times because it includes heavy machinery, Your Lordship. Repair work was going on. I have already invested huge amounts of money, Your Lordship, in setting up the industry, and it has been. this such kinds of matters have been taken up by division benches of this honourable court.
No, it has to be taken by me, single bench.
One more fact, Your Lordship, that is in meantime the third party right has been created.
Your Lordship, only one thing I'd like to point out. The first time when the matter was heard, it was stated that an explanation, a time was sought for basically from the petitioner unit, from the petitioner firms, that you file a supplementary affidavit we needed to file as to in what time will our unit will be operational and back on its leg, Your Lordship. We filed a supplementary affidavit stating that almost we are replacing all the machineries. We need 180 days time. That was also, nothing at that time was brought up by the council for the BIADA, Your Lordship. But later on when the matter...
It's very much apparent that the original persons, they must have given it to someone else.
Yes, Your Lordship.
So, Your Lordship, that is
that I have brought on record, Your Lordship.
That is what it happens.
When the matter was still pending here, Your Lordship, and when it was being heard...
We can see very easily. That is how it happens. The original allottees, they have gone, they have stopped working, and so now you have purchased the entire place and now you want to do it again. Sorry.
Your Lordship, if I could get a copy of the counter affidavit that has been filed and a chance may be given to give a reply to that counter affidavit.
We are looking into your supplementary affidavit, no?
Your Lordship, that was only to the effect that in what time will the unit be operational?
Why? It has not been operational for years together.
Because
it is their own case, Your Lordship. In para 11, they have stated.
The entire machinery must have become a junk. Nothing.
For that reason, Your Lordship, we needed
so now
time
that means the original people who had initially, who was allotted it? Who was allotted this?
The petitioner firm, Your Lordship, Mrs. Sharda Reisman. The petitioner before, Your Lordship.
Where is?
Now it has been allotted to Vejika Foods Private Limited, Your Lordship.
That you have already allotted it to
yes,
someone else?
Third party right has been created.
On the very last occasion, this fact has been brought before the notice of this court as well as the petitioner, Your Lordship. So a copy of the counter affidavit may be supplied to us so that we may peruse the same and a reply may be.
Show the allotment letter.
Your Lordship, the allotment letter is page 44, Your Lordship. Annexure 3 and 4, the original allotment letter along with the licenses that the petitioner firm procured after issuance of the allotment.
No, nothing can be done. You don't have any right. It's a license.
Your Lordship, but
it's a license. It's not an allotment.
It is not, Your Lordship. A license.
Then what is the law relating to license?
Your Lordship, for that purposes, para 34 and 35 of the petition may be taken into consideration. The purpose for which the allotments were made. And thereafter, Your Lordship, we have also stated that the order of cancellation is also bad in law because as per the Act, the authority has to pass an order for cancellation and unilaterally, in this case, the managing director, Your Lordship, has passed an order of cancellation without giving a proper opportunity of hearing, Your Lordship. The very same day I was summoned before the authority, I presented my case and the very same day the order of cancellation was issued, Your Lordship, without proper consideration. That order is Annexure 2, Your Lordship, the original order of cancellation. Thereafter we went in appeal and
In appeal, what happened?
In appeal also, Your Lordship, they did not consider my grounds. Annexure 1 is the appellate order, Your Lordship, and Annexure 2 is the original.
On page 41, it is the operative part of the appeal order.
All right. Anything else?
Your Lordship, it is humbly prayed that huge investments have been made by the
Where is that
parents.
huge investment? It does not show.
And it is not the case of
It's
the.
not, if there had been some huge investment, then we would have definitely interfered.
And your lordship,
It's not functional for years together.
but it was functional, your lordship.
Photographs.
For
Or
3
functional
to 4
means
years.
what? You want to just earn out of it. And why should these Biada not earn it?
Due to some
See, there
personal
is a difference.
Your lordship.
These are leased out lands by Biada and allotted to you for the purpose of setting up an industry. If suppose if you are not setting up an industry or that your industry has already come to close, then the Biada should be allowed to allot it to someone else and put it on auction so that they earn. That is the state how it earns. Otherwise, you are yourself doing it by selling it off to someone else, which we will not allow.
We did not sell it off to
We
someone.
are doing it. We can see it very clearly.
But the case of the petitioner is that they asked for an opportunity, a time for
You
revamping
are just
all the machinery and your lordship.
You just signed it, signing authority. You're not, and we can get it inquired into. If that is so, we will get an inquiry done. And if we find then that your deponent will go behind jail.
Your lordship, another fact that we have already given on oath also that the operational, we are now in a condition that the.
How could you become in condition after 6 years?
Your lordship, due to the COVID pandemic, everyone has suffered losses, including the.
COVID is later on. COVID is later on. Notice was given to you way back in 2000.
It was cancelled in 2019 itself. COVID comes in March 20. Your lordship.
From in the year 17, they asked me to pay the dues, your lordship. It was not for cancellation. I paid the dues in 2019. Even after payment of the dues, your lordship, they went on without considering the fact that I paid the dues. They went on to cancel the allotment, your lordship. That is another point, your lordship. I did pay the dues. It is an admitted position, your lordship. But they did not
consider. Paid the dues then.
Dues anyway they will have to pay, your lordship. There is a provision that is it will be recovered through PDR Act, your lordship. So if they don't pay, we will recover it.
It is the bona fides of the person who is there before this court, which matters.
Yes.
If they have been paying the dues, that means they are interested.
Your lordship, the notices were for both purposes, that is for starting the industry as well as for payment of dues. The dues was of 45,000, they paid it, but they did not start for more than 5 years, your lordship. Even the photographs which they have annexed, it shows the photograph itself shows the condition of the unit.
That we have seen.
We have given ample opportunity, 5 years only for they were liable for 6 months closure, your lordship. But we have given them 5 years, your lordship. And they did not restart the unit.
Give them 6 months. If they establish it within.
But now the third party right has been created, lordship. We have already allotted and the possession has been handed over to one Messrs.
That has been done very recently.
Messrs. Vegika Food Private Limited. After cancellation, the cancellation was done in 2019. Thereafter, we put the plot on the website, your lordship, that if someone is interested, they can apply for the same. And thereafter,
there is no provision for reallotment to the same person.
Provided if it is not, provided if it is not.
And if they have come to the court, then it can be reallotted to them.